Hello students, welcome to Skholar, your one-stop solution for IAS preparation. My name is Anubhav Sir and students, I am your faculty for Indian Polity. Now students, in this module, we'll be continuing with our modules on fundamental rights. We have already covered our first module on fundamental rights, and in this module, we'll be covering the second module. So let's get on with our module. So students, we'll be talking about fundamental rights. We'll be continuing with fundamental rights. In our first module, we have studied about Article 12, Article 13. We had studied what exactly is the meaning of state. We also studied that anything which is done by a legislature or for that matter executive, which is in violation to the fundamental rights of the citizens, which is in violation to the Part 3 of Indian Constitution, that will be held as null and void. We also studied that it is Article 13 which gives the judicial review power to Supreme Court. We have studied that essentially the judgment as to an act or legislature passed by the legislature, is it in violation to fundamental rights or not, this will be determined by Supreme Court, and that is what we call as judicial review. Now students, in this module, we'll be continuing with our understanding of fundamental rights. In fact, we will be focusing on understanding right to equality. So let's start with right to equality. Now students, when we talk about right to equality, what exactly are we trying to say? In our chapter, in our first few modules, we had discussed about democracy. In democracy, we had discussed that essentially democracy is not just about having elections done in a democratic manner. It is also about ensuring democratic ethos and democratic values to be getting followed in the society. Now, one of the cardinal principles, one of the cardinal pillars of any democratic society lies on ensuring that there exists equality. इक्वालिटी जो समानता का अधिकार है, ये बहुत ज़्यादा ज़रूरी होती है अगर हम एक डेमोक्रेसी की बात करते हैं. डेमोक्रेसी को अनेबल करने के लिए ये बहुत ज़रूरी है कि हम इंश्योर कर रहे हैं कि इक्वालिटी प्रिवेल कर रही है पूरी सोसाइटी में. अब जब हम भारत के संविधान को देखते हैं, when we look at our constitution, what exactly do we see? That in our part 3, there is one set of fundamental rights that is ranging from Article 14 to Article 18, and these set of fundamental rights are called right to equality. That is, these rights has been developed in a way in which it is able to ensure that equality is prevailing in the society and each and every citizen in the India are equal to one another. तो इन सेट ऑफ राइट्स को अब हम समझते हैं एक एक करके, बट इससे पहले देयर इज समथिंग दैट वी वुड नीड टू कीप इन माइंड, देयर इज समथिंग दैट वी वुड नीड टू अंडरस्टैंड, एंड दैट इज रूल ऑफ लॉ. We have studied about rule of law, rather we have heard about rule of law before also, but it is important for us to understand the correct meaning of it, क्योंकि अगर हम rule of law को समझ जाएंगे तो हम right to equality के आधार को समझ जाएंगे. We'll actually be able to understand the basis on which rule of law, the basis on which right to equality functions. तो जब हम rule of law की बात करते हैं, what exactly are the things that we need to understand? The first and foremost is जो rule of law का concept है, that got originated in United Kingdom. It was in United Kingdom where the idea of rule of law came about. In fact, it was E.B. Dicey, a political scientist, who had came up with the idea of rule of law. And what exactly did he explain? What he explained was that in rule of law, essentially there will be certain components. The first being that of absence of arbitrary power, the second being equality before law, and third, primacy of the rights of the individual. So let me just explain these three aspects so that it becomes absolutely clear what exactly is rule of law. तो पहली चीज जो E.B. Dicey कहते हैं that there has to be absence of arbitrary power. What exactly does it mean by that? Essentially what he's saying here that in any democracy, if we want people to be equal to one another, we would want that the law that the state is making is getting applied to all of them in a uniform manner, in an equal manner. It cannot be that there is any degree of arbitrariness when it comes to implementation of law, when it comes to implementation of state's power. जो स्टेट की पावर होगी कुछ भी करने की, वो आर्बिट्री नहीं हो सकती, वो अकाउंटेबल होनी चाहिए, वो क्लियर होनी चाहिए, वो प्रोसीजरल होनी चाहिए, and more and importantly it cannot be arbitrary. It cannot be कि एक random policy making हो रही है जिसमें कोई तरीका या कोई प्रोसीजर फॉलो नहीं किया गया है. तो जब हम पहली बात जो रूल ऑफ लॉ में समझते हैं कि जो पावर होगी जो स्टेट एक्सरसाइज करेगा वो आर्बिट्री नहीं कर सकता. अगर उसको कोई ऐसा काम करना है जिसके लिए लेजिस्लेचर की जरूरत है तो पहले उसको लेजिस्लेशन पास करना पड़ेगा, वो एक प्रोसेस से जाएगा, जब वो प्रोसेस कंप्लीट कर लेगा तभी वो कानून बनेगा. अगर एग्जीक्यूटिव है तो एग्जीक्यूटिव को भी उन एस्पेक्ट्स को ध्यान में रखना पड़ेगा जिसके अंतर्गत वो एग्जीक्यूटिव पॉलिसी मेकिंग कर सकते हैं. इट कैन नॉट बी दैट देयर एग्जीक्यूटिव पॉलिसी मेकिंग is taking a form of legislative effect or for that matter judicial effect. So that is the first aspect, कि जो absence of arbitrary power should be there when we talk about rule of law, right? Then there is the second aspect, that is equality before law. What does equality before law means? That law will treat everyone equally. This is the second important aspect of rule of law which we need to keep in mind. जब भी कोई कानून होगा वो ऐसा नहीं हो सकता कि आपने रिच के लिए अलग बना दिया, पुअर के लिए अलग बना दिया. इट कैन नॉट बी दैट लॉ इज एक्टिंग डिफरेंटली फॉर डिफरेंट क्लासेस ऑफ पीपल. लॉ मस्ट ट्रीट ऑल ऑफ द पीपल इन एन इक्वल मैनर. अगर चाहे एक फिल्म स्टार हो जिसने कोई क्राइम किया है और वही क्राइम अगर एक गरीब आदमी ने किया है, उसके लिए जो पनिशमेंट है, उसके लिए जो प्रोसेस है, वो दोनों के लिए ही सेम रहेगा. एंड दैट इज व्हाट वी मीन बाय इक्वालिटी बिफोर लॉ. Now, the third aspect, and this is where some of the students get confused, that primacy of the rights of the individual. What exactly are we trying to say here? Students, this is something on which we had touched upon even in our previous modules. यहाँ हमने क्या बताया था? That state has been given power by the people in order to exercise authority. In their exercise of power, in their exercise of authority, it may very well be that they may start acting in an arbitrary manner, in a despotic manner. In such a scenario, what exactly is required? That whenever we are trying to evaluate the powers of state with respect to, when we juxtapose it to fundamental rights of the people, right to equality of the people, what we would want is that right to equality should prevail over the powers of the state. It cannot be that state in its power is acting in a manner in which it is subverting someone's equality, and that again is a very important aspect of rule of law. रूल ऑफ लॉ का मतलब ये नहीं है कि ऐसा कोई लॉ बन जाए जिसकी वजह से लोगों की इक्वालिटी सबवर्ट होने लग जाए. रूल ऑफ लॉ में ये बहुत जरूरी है कि हम इक्वालिटी को, जो प्रेमिसी होगी इंडिविजुअल राइट्स की, वो इक्वालिटी की, लिबर्टी की, उसको ज्यादा तवज्जो दी जाएगी, उसको प्रायोरिटी दी जाएगी ओवर पावर ऑफ स्टेट टू मेक लॉस. आई होप दिस पॉइंट इज ऑल्सो क्लियर. एसेंशियली हमने तीन बातें याद रखनी है. पहली, एब्सेंस ऑफ आर्बिट्री पावर होगी. सेकेंड, इक्वालिटी बिफोर लॉ होगा. प्रिमेसी ऑफ राइट्स ऑफ द इंडिविजुअल विल बी गिवन विद रिस्पेक्ट टू पावर ऑफ द स्टेट टू मेक पॉलिसीज. और जो रूल ऑफ लॉ था वो यूके से आया, एविटाईसी थे जिन्होंने रूल ऑफ लॉ दिया, राइट. नाउ we will try to understand all the articles. So the first article that we need to understand, it's very very important, that is Article 14. What exactly does Article 14 says? Article 14 says that state shall not deny to any person within the territory of India what? Equality before law and equal protection of the law. What exactly is Article 14 saying? Article 14, as we know, is one of the rights under right to equality. तो सीधी सी बात है, वो right to equality के बारे में कुछ कहेगा. तो Article 14 कहता क्या है कि जो स्टेट है, जो भी गवर्नमेंट होगी, जो भी लेजिस्लेचर होगा, जुडिशरी होगी, जो स्टेट है, दे कैन नॉट डिनाई टू एनी पर्सन विद इन द टेरिटरी ऑफ इंडिया व्हाट? इक्वालिटी बिफोर लॉ. स्टेट ये डिनाई नहीं कर सकता किसी भी नागरिक को दैट यू आर इक्वल बिफोर लॉ, एंड सेकेंड, इक्वल प्रोटेक्शन ऑफ द लॉ. अब बात क्या आती है that for most students they actually think that both these things are the same, but actually they aren't. Let's try to understand what exactly does it mean by equality before law and what does it mean by equal protection of the law. So when we talk about equality before law, what exactly do we see? That everyone is equal in the eyes of the law. So that is the first thing that we need to keep in mind, that equality before law means that everyone is equal in the eyes of the law. Law cannot discriminate between people, between classes. Second, there will not be any special privileges in favor of the person. It cannot be that we are giving some special privileges to one class of the people. So students, here is something that you need to keep in mind. There are two ways in which we can look at it. First, that laws should not be treating two classes of people in a different manner, but it also means that it cannot be that we are trying to establish a social system or legal system where we are trying to give some privileges to few people. If I were to give an example, let me go back to modern history. वहाँ पे आप लोगों ने एल्बर्ट बिल की कंट्रोवर्सी के बारे में पढ़ा था. तो एसेंशियली ये कहता था कि जो इंडियन जजेस होंगे वो जो ब्रिटिशर्स जो इंडिया में काम कर रहे हैं उनके ऊपर उनके केसेस को हैंडल नहीं कर सकते. on the same manner for the same crime which was being done by an Indian, or if it is being done by a Britisher, the punishment used to be different. So what exactly is happening? That the people from British origin are being given some special privileges, and this again cannot be allowed. This again is not permitted under equality before law. I hope this point is clear. All the people are equally subjected to the law of the land. Something which is very obvious, that all the people are subjected to the law of the land, and no one is above the law, whether rich or poor, of high caste or low caste or so-called low caste, of any strata of society, male, female, or in any manner. Then we come to equal protection of the law. So what we have understood what is equality before law. Now we will try to understand what is equal protection of the law. What exactly does it mean? We need to keep in mind three things. First, equality of treatment under equal circumstances, that is your access to legal options, the way in which you will be treated, the punishment that will be inflicted on you, the procedure of investigation that will be done, all of those aspects will mean that there is equality of treatment under equal circumstances. Secondly, similar laws should be similarly applied to all people. Now, it's one thing that we are trying to create a law and we say that it is applicable to everyone, but we would also want to ensure that the law which is similar, the law which is same, is also getting implemented in the same manner. फॉर एग्जाम्पल, अगर कोई केस आता है जिसमें लेट्स से चोरी का केस है, इट कैन नॉट बी कि जो प्रोसीजर है, जो मॉडुलस ऑपरेंडी है स्टेट का टू डील विद सच क्रिमिनल्स चेंजेस फ्रॉम पर्सन टू पर्सन. This again is very important for us to remember, because if such a thing is happening, it will be violation of Article 14. In fact, students, there are several cases of rape which is happening mainly the northern part of India, although it is something which happens all over the world. So what do we see? That a lot of times police is acting in a manner in which they are trying to not go as hard on people who come from socially influential classes. In such cases, generally what happens is, whenever a petition is filed on behalf of the woman, the lawyer also claims that it is a violation of Article 14 of his client, for the reason that police is not acting against the socially influential people in the same manner as they would have acted against a person who is not so socially empowered. This again is something that you need to keep in mind, that Article 14 is not just about equality before law, but it is also about that similar laws are getting implemented in a similar manner. Like should be treated alike without discrimination is at the heart of what? Of Article 14 of equality of equal protection of law. Now, another caveat, another thing that must be kept in mind, that these provisions enable the Constitution to provide special provisions for SCs, STs, OBCs and women, and it is known as affirmative action. Now, students, here again, there could be a confusion that might be coming in your mind. कि सर एक तरफ तो आपने ये बताया कि we have something called equality before law, आपने ये भी बताया equal protection of law, बट देन आप कह रहे हैं कि यही सोर्स बन जाता है, दैट इज जो बी पार्ट मैंने आपको बताया, इक्वल प्रोटेक्शन ऑफ लॉ, जहाँ पे हम लोग स्पेशल प्रोविजंस, चाहे वो अफर्मेटिव एक्शन जिसे हम कहते हैं, चाहे वो रिजर्वेशन हो सकता है, जैसे आपने अगर मेट्रो में देखा हो सीट्स रिजर्व होती है वुमेन के लिए, तो ये चीज कैसे फिट बैठ रही है? एक तरफ हम इक्वालिटी की भी बात कर रहे हैं, दूसरी तरफ हम रिजर्वेशन की भी बात कर रहे हैं. Essentially, students, what we need to understand is that when we talk about Article 14, it must be read in the light that essentially like should be treated alike without discrimination. That is, people of the same class, people of the same structure, same subclass are being treated in a similar manner. अगर कोई एक aspect में similar है, it cannot be the same. The two persons are being treated in a different manner. For example, SCs के लिए रिजर्वेशन होता है, तो ऐसा स्टेट नहीं कर सकती कि भाई इस पर्टिकुलर SC, चाहे वो एक कम्युनिटी का आता है या दूसरी कम्युनिटी का आता है, उसको प्रिविलेज दी जाएगी दूसरी कम्युनिटी पे. अगर ये आइडेंटिफाई हो गया है कि ये एक्स नंबर ऑफ जो कास्ट है या एक्स नंबर ऑफ जो लोग है ये आते हैं SC में, तो ऑल ऑफ देम विल बी गिवन इक्वल अपॉर्चुनिटी विद इन द कम्युनिटी ऑफ SC. तो अगर कोई रिजर्वेशन होगा जो SC के लिए एप्लीकेबल होगा, ऑल ऑफ दिस पीपल आर इक्वल स्टेक होल्डर्स इन क्लेमिंग दैट रिजर्वेशन. I hope this point is clear. What exactly are we trying to say? What we are trying to say is कि जब हम बात करते हैं आर्टिकल 14 की, वो इक्वालिटी की तो बात करता है, बट इक्वालिटी को वो देखता है where the principle like should be treated alike without discrimination. जो लोग सेम क्लास के हैं, जो लोग सेम डिवीजन के हैं, उनको उसी तरह से the way in which they will be treated, जो लॉ उनके ऊपर इम्प्लीमेंट होगा वो सेम होगा. Let me give you one more example and that will be a lot more simpler. जब हम लोग मेट्रो में जाते हैं, हमने देखा है कि there are seats which are reserved for women, but it doesn't say that women will need to be of this caste, women will need to be of this age, woman needs to be of from North India or South India or this region, nothing of that sort. What exactly it says? That women are eligible to sit here, these seats are reserved for women. So any woman can actually go and claim to sit over there if a male person is sitting, or for that matter if it is vacant. So what exactly have we understood? That for this reservation, this affirmative action of reserving seats in metro for women, all the class of people, all the class of citizens within that class, that is जो women है यहाँ पे, all of them will be treated equally. All of them have the right to go and sit over there. I hope this point is now clear. What exactly I am trying to explain कि affirmative action को, जो reservation को इस कंटेक्स्ट में देखना जरूरी है आर्टिकल 14 में, जिसमें लाइक्स विल बी ट्रीटेड अलाइक व्हाइल अनलाइक विल बी ट्रीटेड इन अ डिफरेंट मैनर. नाउ वी कम टू व्हाट एग्जैक्टली द सुप्रीम कोर्ट से ऑन आर्टिकल 14. दिस अगेन इज वेरी इंपॉर्टेंट बिकॉज इट गिव्स अस फर्दर मोर क्लैरिटी एज टू हाउ वी मस्ट अंडरस्टैंड आर्टिकल 14. The Supreme Court has held that where equals and unequals are treated differently, Article 14 does not apply. The point which I just explained, that if there is a class of people which is being treated in a similar manner and there is another class of people who are being treated in a different manner to this class of people, that doesn't mean Article 14 का violation हो गया है. अगर हमने women को reservation दी है with respect to seats in metro, इसका मतलब ये नहीं है कि men ये claim करे कि Article 14 हमारा violate हो रहा है, क्योंकि यार नहीं हो रहा है. हमने class of citizens को देखा है, हमने women ऐसा class को treat किया है. Thus, Article 14 permits reasonable classification of persons, objects, transactions by the law, but the classification should not be arbitrary, artificial and evasive. Let me just explain this point again. So essentially Supreme Court ने ये बोला that देखो Article 14 is something that does not get violated if laws are being made for different classes of people. Let's say अगर बच्चों के लिए एक law बनाया गया, तो it doesn't mean कि एक एडल्ट आके ये बोले कि भाई क्योंकि ये चीज बच्चों को मिल रही है तो मुझे भी मिलनी चाहिए, और ये नहीं मिल रही है मतलब आर्टिकल 14 का वायलेशन है. बिल्कुल नहीं, ये चीज हम बिल्कुल परमिट नहीं करेंगे. एट द सेम टाइम इट इज नेसेसरी कि हम जो क्लासेस बना रहे हैं वो एक लॉजिकल ग्राउंड पे बना रहे हैं, वो एक इलॉजिकल ग्राउंड पे नहीं बना रहे हैं. जो रीजनेबल क्लासिफिकेशन हो रही है वो इस ग्राउंड पे हो रही है जो रैशनल हो, जो आर्बिट्री ना हो और जो एक मॉरल एंड को सर्व करे. लेट मी गिव यू अनदर एग्जांपल ऑफ इट जहां आपको ये चीज एकदम क्लियर हो जाएगी. Few years back, one of the controversy that had came about was कि सुप्रीम कोर्ट ने ये कह दिया था कि जो इलेक्टेड जो सिटिंग MPs and MLAs है, अगर उनके खिलाफ कोई भी केस में उनको कन्विक्शन मिल जाती है, if they get convicted in any of the cases which were pending, so these members will need to vacate their seat with immediate effect. जैसे ही उनको कन्विक्शन मिल गया किसी भी कोर्ट ऑफ लॉ में, they will become disqualified and thus they would need to leave their seat of MP or MLA. अब इस चीज के लिए जो लॉजिक जो स्टेट दे रहा था वो ये दे रहा था कि जो सिटिंग MP एंड सिटिंग MLA है वो एक रीजनेबल क्लासिफिकेशन है. एज सच दे कैन नॉट बी ट्रीटेड अलाइक टू अदर सिटीजन. कहने का मतलब ये कि अगर इलेक्शन नहीं हुआ होता और लोग अप्लाई कर रहे हैं टू फाइट फॉर दैट सीट, तब बर्डन ऑफ प्रूफ होता हर कैंडिडेट पे कि उसको ये बताना पड़ेगा कि ही हैज नॉट बीन कन्विक्टेड इन कोर्ट ऑफ लॉ. लेकिन अगर वो सिटिंग MP MLA है और वो कन्विक्ट हो जाता है, द ही कैन नॉट बी ट्रीटेड इन द सेम मैनर जिस तरीके से वो कैंडिडेट्स ट्रीट होते जो उस इलेक्शन में खड़े हुए हैं. और जो स्टेट था, जो गवर्नमेंट थी, उन्होंने एक्सप्लेनेशन ये दी कि जो सिटिंग MP एंड सिटिंग MLA है, दैट इन इटसेल्फ इज फॉर्मिंग अ क्लास ऑफ सिटीजंस. I hope you are able to understand the point, and this was taken by Supreme Court as unreasonable grounds to classify citizens. It cannot be that people who stood in election, जो candidates थे, and people who won the election are being treated in a different manner when it comes to application of disqualification norms, disqualification rules. I hope this point is absolutely clear that while different laws or different rules can be made for different classes of citizens, What cannot be done is that determination of class is being done in an arbitrary manner, in an illogical manner, and in a manner in which you are trying to be evasive. This again is something important for you to remember. Now we come to Article 15. What exactly does Article 15 says? It says that state shall not discriminate against any citizen on grounds of only religion, race, caste, sex, or place of birth. Now students, this again is very important for you to remember. Each and every criteria on which discrimination against the citizens cannot be done by the state, that is religion, race, caste, sex, place of birth. What exactly is Article 15 saying? What it's saying is that state will need to make policies. In order to make policy, state would need to give some specifications. The nature of these specifications, the nature of these policies cannot be of a nature where it is discriminating on between citizens, among citizens, and the grounds on which discrimination is happening is religion. That we are trying to make one policy for one religion and different policy for some other religion, that cannot be permitted. On race, that we are trying to say that people of this race are being given privilege or any kind of special sort of benefit over the people of different race, this cannot be permitted. Caste, that it cannot be that certain privileges are being reserved for one caste and not for the other caste. Sex, that cannot be that for male and female, the terms of engagement, the way in which they need to operate are different. And then place of birth, that it cannot be that since you were born in one part of India and not in this part of India is why you will not be given privilege. Important to note here that these are the 5 criteria which have been mentioned in Article 15, and you would need to mug it up, you would need to remember them because it has been asked in several PCS and in UPSC examination. There is no reason why they may not ask it again, mainly in the statement form of questions that they are asking. Then what exactly do we mean by it? Let's try to understand that these provisions apply with regard to what? Access to shops, that is public restaurants, hotels and places of public entertainment. What exactly are we trying to say? That if there is a shop, if there is a public restaurant, if there is a hotel, if there is a place of public entertainment, and the set of people who are controlling the shop or public restaurant, if this allowing one race of people while they are allowing different race of people, if they are disallowing people of certain faith and they are allowing people of different faith, this cannot be permanent. कि ऐसा नहीं हो सकता कि आप कोई रेस्टोरेंट की बात करें जहाँ सिर्फ ये अलाउड है we will serve only to Muslims and we won't serve to Hindus. This is something that cannot be allowed. It cannot be that we are serving only to males, we will disallow service to women. This cannot be allowed. This will be violation of Article 15 of that woman. This is what the first part of Article 15 is saying and something that we need to keep in mind. Then it also says that even with respect to use of wells, tanks, bathing ghats, road and places of public resort maintained wholly or partly by state funds or dedicated to the use of general public. This again is something that we need to keep in mind, that there are certain places, for example wells, for example places in the rivers there are places of public bath, right? Bathing ghats is what they are trying to say. Then use of roads. What cannot be allowed is that we are disallowing one section of people on the basis of religion, race, caste, sex or place of birth while we are allowing a different section of people. In fact, students, there was a very important intention behind it, including this provision in the Indian Constitution Article 15, because that was a social malpractice that used to happen. कि जो हाई कास्ट के लोग होते थे वो वेल यूज नहीं करने देते थे लो कास्ट के लोगों को. दिस इज समथिंग व्हिच इज इवन टुडे हैपनिंग and it was felt to be very necessary, but to be very pertinent on the part of Constituent Assembly to explicitly mention in the Constitution itself कि ये जितनी भी practices है जहाँ use of tanks, use of wells, bathing ghats वगैरह लिमिट कर दी जाती है only few classes of people के लिए और दूसरों को डिसअलाउ कर दिया जाता है, ये हम परमिट कर ही नहीं सकते हैं. Right? Even with respect to access to roads, अगर हम South Africa का example ले, even in some places in India, it used to be that the natives cannot walk on certain roads and only the Britishers can actually walk on those roads. What exactly is happening? A kind of discrimination is happening on the basis of race, on the basis of region. This is what Article 15 is talking about, that this is not permitted. Any such policy made by the state will not be allowed. Now, Provision B prohibits discrimination both by state and by individuals, while Provision A is prohibiting discrimination only by state. Again, an important point that you need to keep in mind. Now, there are certain exceptions with respect to Article 15, and let's try to understand them. That state is permitted to make any special provision for women and children, a point that I have already covered. The whole idea is that same class of people will be treated in a similar manner, but different classes of people can be treated in a dissimilar manner. So, if any policy is being made by state with respect to women, जैसे कि मैंने बताया मेट्रो में कुछ सीटें रिजर्व रहती हैं, और फॉर दैट मैटर देयर इज रिजर्वेशन फॉर वुमेन इन लोकल पंचायत, that is absolutely permitted and that cannot be seen as violation of Article 15. Then the same applies for children. State is permitted to make any special provision for the advancement of any socially and educationally backward classes of citizens, जिसको हम कहते हैं backward caste, backward classes, scheduled caste and scheduled tribe. This again is something that we need to keep in mind. This again applies to the same, the principle which is applicable here is exactly the same that I explained. कि अगर state देखता है that there is a class of citizens जो socially backward है, जो educationally backward है, और उनके लिए special privileges लाता है, special policies लाता है, that cannot be taken as violation of Article 15. In the same manner, if there are policies, if there are programs that are being made for upliftment of scheduled caste and scheduled tribes, that again is not a violation of Article 15. For their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. This was added in 93rd Constitutional Amendment Act. What exactly is it saying? What it's saying is कि अगर socially and educationally backward classes को identify किया state ने, और वो स्पेशल प्रिविलेजेस करता है विद रिस्पेक्ट टू एजुकेशन, एडमिशन एजुकेशनल इंस्टीट्यूशंस, और फॉर दैट मैटर इवन इन प्राइवेट एजुकेशनल इंस्टीट्यूशंस, अगर वो रिजर्वेशन को लाता है, दैट इज एब्सोल्युटली परमिटेड. और ये जो अमेंडमेंट था ये 93rd कॉन्स्टिट्यूशनल अमेंडमेंट के बाद आया था. नाउ लेट्स ट्राई टू अंडरस्टैंड सम इंपॉर्टेंट एप्लीकेशंस ऑफ आर्टिकल 15. The first important application is reservation for women in local bodies, a point which I just covered. जब हम लोकल बॉडीज को देखते हैं, what exactly do we see? That women reservation is there in local panchayat. We know that 33% of the seats are reserved for women. Yes, again, it's not a violation to Article 15. If at all, one can argue it to be the application, because it clearly says that state is permitted to make special provisions for women. Thus, हमने reservation दे दिया. Then we had Vishaka guidelines on sexual harassment at workplace. What are these Vishaka guidelines? Essentially, these are those guidelines which were made by Justice Verma way back in 1996, which was meant to prevent sexual harassment of women. While it will take some time for us to discuss it, essentially what we need to keep in mind is कि Justice Verma ने इस चीज को समझाया that if there is a work environment where women are feeling unsafe, what exactly is happening? There is violation of Article 15 of the woman is happening, violation of Article 14 is happening, and we will need to do something about it. In order to do so, what is required is set of guidelines, set of laws by which we are able to take actions against those people who are indulging in sexual harassment of the women. As such, what do we see? That Vishaka guidelines was passed, and the fact that sexual harassment with respect to women was included does not mean that it is violation of rights of men, for the reason women as a class are being given special privileges, keeping in mind the context, keeping in mind the social milieu, जो समाज में जो रियलिटी है उसको चीज को ध्यान में रखते हुए विशाखा गाइडलाइंस बनाई गई थी. वुमेन की प्रोटेक्शन के लिए बनाई गई थी. मेन ये नहीं क्लेम कर सकते कि सेक्सुअल हरासमेंट उनके अगेंस्ट जा रहा है ये कानून, क्योंकि सिर्फ मेन ही हो सकते हैं जो आई मीन दोज कैन बी डीम्ड एज पीपल हु आर परपेट्रेटर्स इन दिस केस, क्योंकि आर्टिकल 15 इसकी पूरी तरह से इजाजत देता है. Then we have in 2018, adultery law under Indian Penal Code Section 497 was decriminalized for not being gender neutral, as it did not allow women to file complaint against an adulterous husband. This is a different way in which we need to understand Article 15. That essentially there was a law, that is adultery law. What exactly did it say? It said that a married woman is the property of her man, And if a man is indulging in adulterous activity, the husband is indulging in adulterous activity, woman cannot, the wife cannot go and file a complaint against it, and that was perceived as not being gender neutral, that was being perceived as violation of Article 14 and Article 15 of the Women, and thus this law in 2018 of this thing was changed, that is Section 497 was decriminalized. I hope this point is very clear. Now we come to Article 16. Article 16 provides for equality of opportunity for all citizens in matter of employment or appointment, and no citizen can be discriminated and be made ineligible for employment on the grounds of only religion, race, caste, sex, descent, place of birth, or residence. This again is very important for us to understand here. That what exactly is it saying? That there has to be equality of opportunity for all citizens and there cannot be any discrimination that can happen. And Article 16 in itself is mentioning those criteria, those grounds on which discrimination cannot happen, and that is mentioned over there. But even with respect to Article 16, there are certain exceptions that we need to understand. The first such exception is with respect to residence. That residence as a condition for certain employment or appointment in a state or union territory or local authority can actually be prescribed by the parliament. That is, if parliament believes that residence is important in order to ensure effective recruitment of the people, parliament is very much empowered to do so. Then, state can also provide for reservation of appointments or posts in favor of any backward class that is not adequately represented in the state services. If state believes that, well, we would need certain reservation for some of the people who are residing within the state, and these set of peoples are first coming in the backward classes and second are not getting adequately represented in the state services, certain reservations can be given. In fact, students, if you notice that there are certain sections, there are certain communities which are getting reservation within their state, but they are not getting reservation in the center exams, in the union examinations, right? Then, in fact, there is this controversy with respect to Marathas being given reservation within Maharashtra services. So that is what the context is all about. That state can also determine those classes within their state who are residing and who they believe to be backward, and second, not being adequately represented in these services. Then we come to point 3. A law can provide that the incumbent of an office related to religious or denominational institution or a member of its governing body should belong to a particular religion or denomination. What exactly does this point 3 says? बहुत आसान सा है, बहुत आसान भाषा में समझना है. That when there is Article 16, what exactly is it saying? That there has to be equality of opportunity. It cannot be कि अगर कोई जॉब है उसके लिए हम लोग opportunity को इस लेंस से देखें कि कौन से रिलीजन का आता है. That cannot be certainly permitted. कि अगर चाहे हिंदू हो, चाहे मुस्लिम हो, चाहे सिख हो, कोई भी रिलीजन का हो, अगर वो जॉब की क्राइटेरिया में मेरिट में आ जाता है, वो एग्जाम क्लियर कर लेता है, वो मेरिटोरियस है, तो उसको वो अपॉर्चुनिटी मिलनी चाहिए. स्टेट कैन नॉट डिस्क्रिमिनेट. बट आर्टिकल 16 एक बहुत इंपॉर्टेंट कैविएट ये देता है that there could be certain positions जहाँ पे religion can become a criteria. For example, मान लेते कोई मंदिर है और इस मंदिर में we would need to appoint a pujari. In order to appoint a pujari, one of the basic cardinal necessity will be that this pujari is from the religion of Hinduism. It cannot be that a person who practices Islam is being given the position of pujari of a mandir. Thus, Article 16 इस चीज को क्लियर कर देता है. With respect to such matters, state can actually make appointments where religion of the person can be a criteria. I hope this point is also clear. Now we come to Article 17. What exactly does Article 17 says? It essentially abolishes untouchability. What is untouchability? That is a crude practice that is being done in India. Article 17 says that untouchability is prohibited. Untouchability is not allowed, जिसको छूत अछूत भी कहते हैं हिंदी में. तो what exactly do we need to understand? That there is a protection of civil right 1955 which was enacted in order to give effect to Article 17 of Indian Constitution. Article 17 ने ये कहा that the Constitution of India is abolishing untouchability. But ये कह देना तो काफी नहीं है ना. We would need to have a legislature which is able to implement it. In order to implement it, there was Protection of Civil Rights Act of 1955, जिसने बताया what all things can be amounted as untouchability, what will be the degree of punishment for a person who is found to be guilty of practicing untouchability. उसके लिए ये कानून बना था. The term untouchability has not been defined either in the Constitution or in the Act. Untouchability, as to what exactly does it mean, what comes and what doesn't come under it, is something that has not been clearly defined. Essentially, बात क्या हो जाती है that there are so many ways in which such a malpractice, social malpractice can happen where untouchability का effect दिखे. In fact, in a recent judgment of Sabrimala, Justice Chandrachud had actually said that the practice of discriminating women on the basis of their time of the month, that is, they are menstruating, if they are being discriminated on this criteria, that since you are menstruating, you are impure, that has an effect which is equal to that of untouchability, that has an effect which is violation of Article 17 of the Women. Thus, what do we see? Even our understanding of what does and what doesn't come under untouchability is also evolving, is also expanding. Thus, it makes less sense for us to limit the idea, the understanding of untouchability into few sentences. I hope you get the point that untouchability has not been defined clearly either in the law or for that matter by the Constitution. It is something that has been left to the understanding of the state in terms of determining whether an act which has been brought to its notice amounts to untouchability or not. Then we have enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with the law. What exactly does it mean? It's very simple. All it's trying to say is कि अगर untouchability की वजह से किसी को disadvantage मिलता है किसी भी तरीके से तो इसको भी offence माना जाएगा. So it's not necessary that there has to be clear evidence of untouchability being practiced. If at all evidence has been produced between the court जो इस चीज को establish करता है कि जो एक तरह का disadvantage कर दिया गया एक व्यक्ति को because वो एक lower caste का आता है with respect to access of opportunity, with respect to treatment of equality and so on and so forth, उसको Article 17 की avail ना माना जाएगा. That will also be considered as exploitation of the person, violation of Article 17 of the individual. तो हमने क्या समझा? पहली चीज, untouchability has not been defined by the Constitution or for that matter Protection of Civil Right Act of 1955. Civil Right Act of 1955 क्या था? वो बेसिकली untouchability के खिलाफ जितनी भी कदम है, जो पॉलिसीज है, जो लॉस है, उसको बताता है. वो पनिशमेंट भी बताता है, वो मॉडल्स ऑपरेंडी भी बताता है, बट वो untouchability क्या है ये नहीं बताता है. उसका रीजन ये है कि untouchability has been evolving with time. दूसरी चीज कि अनटचेबिलिटी नीड नॉट बी शोन ओनली इन दी मैटर्स जहां पे एकदम डायरेक्ट अनटचेबिलिटी का केस हो. अगर कोई तरह से डिसएडवांटेज क्रिएट किया जा रहा है एक सेट ऑफ सिटीजन्स के लिए क्योंकि वो एक लोअर कास्ट से आते हैं, उसको भी अनटचेबिलिटी माना जाएगा. So there is a Mysore High Court's observation which I think is very important for us to understand so that we are able to clearly understand Article 17. What does it say? It says that the subject matter of Article 17 is not untouchability in its literal or grammatic sense, but it is the practice as developed as an historical practice which was developed in India. What is it trying to say? It says that untouchability is not just about कि आप किसी को you're not going to touch someone just for something. It is not the literal meaning only. It is not the grammatic meaning only. It is something that is trying to capture the social injustices that has been inculcated, has been kind of inflicted on the people of a certain caste or people of a certain class. इस चीज को untouchability term में capture किया गया है. It refers to the social disabilities imposed on certain classes of persons by reason of their birth in certain caste. It is about कि क्योंकि कोई व्यक्ति एक कास्ट में, एक क्लास में पैदा हुआ है और इस वजह से वो एक डिसएडवांटेज पोजीशन पे है, ये एक सोशल इवल है. दिस इज अ सोशल मैल प्रैक्टिस व्हिच इज हैपनिंग एंड अनटचेबिलिटी इज ट्राइंग टू इंडिकेट टू दैट. इट इज नॉट जस्ट अबाउट दैट यू आर नॉट टचिंग समवन, यू आर ट्राइंग टू अवॉइड टच समवन. इट्स नॉट जस्ट द लिटरल इंटरप्रिटेशन. Hence, it does not cover social boycott of a few individuals or their exclusion from religious services. So, what it does not cover कि अगर कुछ लोग को मना कर दिया है कि आपको एक्सेस टू मंदिर नहीं मिलेगा और फॉर दैट मैटर एक्सक्लूजन कर रही है सोसाइटी उनको, दैट डजंट मीन कि उनके खिलाफ आर्टिकल 17 का वायलेशन हो रहा है. ऐसा हो सकता है दैट पर्सन, लेट्स से पर्सन एक्स हैज डिसेक्रेटेड a mandir, and the pujari believes that this person should not be allowed to enter the mandir for the reason he has desecrated it. That person cannot claim that my Article 17 has been violated. The question of Article 17 will rise only in those matters where historic injustices with respect to a certain community is established, and there is a kind of disadvantaged position that the people of that community is being put on the matter which has been brought to the court. कोई ऐसा matter court के सामने लाया गया है यहाँ पे discrimination is being done on the basis of caste, and that caste, the person of that caste is historically established to be a disadvantaged, a discriminated caste. I hope this point is clear. It's very important for us to remember. Then we come to Article 18. This Article 18 is very simple. What exactly does it say? It talks about abolition of titles. Now students, in Right to Equality, we had discussed that it's one thing that we create a society where everyone is equal, that the people of certain caste are not being put at a disadvantaged position. But it also means that we are also treating people, we are not keeping some of the people at a privileged position. अगर हम ये चाहते हैं कि हर लोगों को अनइक्वली ट्रीट ना किया जाए, उसका एक एस्पेक्ट ये भी है कि कुछ लोगों को प्रिविलेज पोजीशन पे ना रखा जाए, कुछ लोगों को डिसएडवांटेज पोजीशन पे ना रखा जाए, पर एट द सेम टाइम ऐसा भी नहीं होना चाहिए कि कुछ लोगों को हमने प्रिविलेज पोजीशन पे रख दिया है. ये जरूरी इसलिए था क्योंकि एट द टाइम ऑफ इंडिपेंडेंस ब्रिटिशर्स यूज्ड टू क्रिएट क्लासेस ऑफ सिटीजंस एंड दे यूज्ड टू गिव देम टाइटल्स, राय बहादुर, चौधरी, so on and so forth. All sorts of titles were being given by the zamindars, by the Britishers, and these titles used to come with certain privileges. It was understood, it was accepted by the Constituent Assembly that we cannot have such a system to continue in an independent India which strives to be a democracy. Thus, it prohibited the state from conferring any title, military or academic, except a military or academic distinction to anybody, whether citizen or a foreigner. It cannot be that you are giving away titles. It also prohibits a citizen of India from accepting any title from any foreign state. So if you are a citizen of India, you cannot accept any title from a foreign state, because if you are doing so, essentially, you are actually trying to get into a privileged group, something that Constitution of India is not permitting. Another important thing, that when we talk about national awards, Supreme Court has upheld the constitutional validity of some of the national awards, that is Bharat Ratna, Padma Vibhushan, Padma Bhushan, Padma Shri. And what we need to keep in mind is that these are ways in which we are giving them civic honors. These are not the titles that is being given to them. The civic honors are being given for their exceptional services for the society. What needs to be kept in mind, that they cannot use them as suffix or prefix on their names, and if they are using so, state can instigate an inquiry and can even remove the title. So let's say we have Sachin Tendulkar, who is Bharat Ratna, right? So Sachin Tendulkar cannot use Bharat Ratna in his name, be it as a prefix or a suffix. Yes, people can call him that we have Sachin Tendulkar, who is a Bharat Ratna, and we are kind of inviting him on the stage or anything. But what cannot be done is that Sachin Tendulkar himself start using Bharat Ratna in his name, because that will have an effect of the title, something that Article 18 is not permitting. So students, this is all we had for Right to Equality. So what exactly have we understood? We understood Article 14, that is equality before law. We understood about Article 15, prohibition of discrimination on the grounds of religion, race, caste, sex or place of birth. We also understood about Article 16, that equality of opportunity in matters of public employment. Students, within Article 16, there are several provisions. It also talks about Article 16, subclause 4 actually talks about reservation, that state can actually confer reservation in order to uplift people from backward classes. We also have Article 16 4A, that is that state can also make provisions for reservation in matters of promotion. That again is something that you need to keep in mind. Then we have Article 17 that talks about abolition of untouchability. With respect to abolition of untouchability, we also studied about the judgment of Mysore's High Court, which throws insight as to how we must understand Article 17, that it is not just about the act of untouchability in terms of its grammatic sense, but also the whole idea of historic injustices that has happened against certain sections of the community. Then we also understood about abolition of titles. In Article 18, we also studied about how national awards cannot be used as titles by the people who have won these. This is all we had for this. lesson, this module. If you have any doubts, please ask us. For more such lectures, please log on to Scholar and watch these videos. Thank you guys.